Chief Justice David Maraga has indicated that judiciary budget cuts will further derail the process of justice. Maraga aims to clear over 60,000 cases that have been pending for between 5 to 10 years by the end of the year. The judiciary, however, faces an uphill task in maintaining the tempo of its drive towards efficiency, with drastic budget cuts threatening to bring to a halt a total of 70 ongoing court modernization and construction projects seen as critical to the success of the Judiciary Transformation Framework. According to Maraga, the downward revision of judiciary funding capped at 17.3 billion Kenya shillings in the 2018-2019 National Budgetary Policy Statement to 14.5 billion shillings in the Appropriation Act had left the judiciary with only 50 million Kenya shillings in development budget. Mobile courts have since been suspended due to inadequate funding. Maraga was speaking when he officially opened the Annual Judges Colloquium in Mombasa alongside visiting South African counterpart Mogoeng Mogoeng.
And I'm glad that we have made significant progress in this area. Just a little over 110,000 cases, in fact to be precise, 111,973 are the cases pending as of 30th of June this year, are the cases which are more than 5 years old pending in our courts. We put together plans and made arrangements to have service weeks in various stations, and I'm assured that we are clear this backlog by the end of this year. I want once again to call upon all of us to rededicate ourselves and make sure that we clear these cases by the end of the year. Besides these station-based initiatives, there are many judiciary-wide initiatives that hold great potential for enhanced efficiency. We recognize, for example, that technology can play a key role in bringing justice, in bridging the justice gap. That's why I put the Judiciary Transformation Framework and sustaining judiciary transformation so strongly emphasizes the use of ICT, having recognized its potential in enhancing access to justice. We have, for example, put in place an ICT policy and drawn an ICT master plan. This makes it clear what everyone's obligations are and the procedures to be followed to ensure safe, effective, and the use of ICT. Fellow judges, as you know, the Constitution also provides for alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute mechanisms that should be promoted. Indeed, not many of us know that many of the disputes that our people experience are resolved without coming to court. Research has shown that there are other avenues outside the courts that Kenyans use to address their conflicts. The Constitution is alive to this reality and has called upon the judiciary to facilitate access to these alternative forms of justice delivery. I therefore urge all of us to encourage the parties to employ these alternative methods of conflict resolution, not only because they are a constitutional imperative, but also due to their potential to enhance effectiveness and the delivery of justice in our country.
Judicial leadership is very unique. I will never listen to anybody who says leadership is leadership. Judicial leadership is very unique. But it becomes problematic because some of us who occupy positions of leadership have never led anywhere. You are an attorney or an advocate, you have your PA, who else do you have to lead? Otherwise you lead your family. And then, because of your exceptional knowledge of the law, you get appointed to a judicial office. Some even come straight, like my brother and friend, the president of the Federal Constitutional Court of Germany, Vogule, straight from university, president of the court. How is he going to lead? The same applies to the Chief Justice of the United States Supreme Court, Robert.